Okay, everybody, so I'd like to introduce our second panel on executive evidence of torture, and executive action, focusing on CSIS, the RCMP, and the CBSA with perspectives from abroad. And to chair this panel, we're very fortunate to have with us adjunct professor here at Osgoode Hall Law School, formerly full professor, so Professor Ron Atkey, who's been a very big help in organizing this conference. Ron, the floor is yours.
Thank you, Francois. I'm going to chair this panel. Thank you for the reference to my national security law course, which is now ended, although the marks haven't yet been released. I do see some students here. My main experience in this field is as a watchdog of CSIS, although I've had some other dealings with the other agencies that we're going to focus on, the RCMP and the CBSA. I'm pleased to welcome our panelists here today. Professor, to my right, David Cole of Georgetown University in Washington, and a very special welcome to Ray Boisvert, who is the former Assistant Director of Intelligence at CSIS. He's been there before, although not currently representing that agency. And of course, one of the preeminent scholars in this field, Kent Roach of the University of Toronto. Welcome to all three of you. Now, since you're all eminently qualified to speak on this main issue before the forum, and their credentials are well known, in the interest of time and a full Q&A session, I'm not going to elaborate on their impressive careers, but I'm going to try to put the Canadian government's actions in dealing with information sharing and mistreatment in the context of the past 10 years since 9/11. In my view, and this is just one person's take, there are three important cases concerning torture that have established benchmarks in Canada involving government action and judicial responses. First, there is the case of Suresh, which Barb Jackman mentioned, in which she was one of the prominent counsel, involving deportation of a suspected Tamil terrorist to torture. And while Suresh's appeal was allowed in the Supreme Court of Canada on a Section 7 due process ground, the court supported reduced disclosure to safeguard confidential public security documents and emphasized that the minister must be allowed considerable discretion in evaluating future risk and security concerns. And this has become known in our teaching and in our jurisprudence of national security as the Suresh exception, and it continues as the law of the land. The second case involves Mir Arar, and this has come up before in today's discussion. Now, all of us on this panel have had some involvement with Mir Arar, either as counsel or as investigator or as amicus curiae before the O'Connor Commission or as commission researcher. And to recall that case, it's important to remember the facts resulted in a public inquiry headed by Justice Dennis O'Connor in 2004 through 2007 to get to the bottom of the Canadian officials' part in the extraordinary rendition to Syria of Mr. Arar, a Canadian from Ottawa. The rendition took place from JFK Airport in New York in 2002. He was kept in captivity and tortured for 9 months in various forms or other. With what's not torture, it certainly was CID. His rendition by the CIA, openly acknowledged, was based on faulty information provided by the RCMP. And the delay in his being returned to Canada from Syria involved complicity of both the RCMP and CSIS. And he was eventually brought home only after urgings by DFATE, who persuaded Prime Minister Chrétien to intervene. And Justice O'Connor's report provided useful guidelines on information sharing, and the Canadian government apologized to Arar and compensated him to the tune of some $10 million. And I know Kent Roach is going to have more to say about this because of his direct involvement in that case. The third case is Omar Khadr, another Canadian. He was taken, and again to repeat for some of you who may not have followed it as closely, he was taken prisoner at age 15 in July 2002 by U.S. forces in Afghanistan after allegedly throwing a grenade killing a U.S. soldier. And he was transferred to Guantanamo Bay, tortured and held until September 2012, just this past year, when he was finally transferred to Canada to serve the balance of an 8-year sentence following a plea of guilty before a military commission in 2010. And it is clear from what we know that during his 10 years of detention at Gitmo, he was interviewed by agents from CSIS and DFATE who shared this information with U.S. authorities until our federal court intervened in finding his Section 7 charter rights had been violated. But while upholding Khadr's Section 7 charter rights, the Supreme Court of Canada in 2010 refused to order the Canadian government to request the U.S. to return him to Canada on the grounds that the court should not intervene in matters of foreign relations. So it's against the background of these three cases that we have the government of Canada on June 25th, 2010, when it was still a minority government, preparing and distributing internally to deputy ministers and agency heads a secret document entitled Framework for Addressing Risks of Mistreatment in Sharing Information with Foreign Entities. Decisions to share information involving risk of mistreatment are to be made by the deputy minister or the agency head with or without the consultation of the minister, taking into account 7 factors, and there's a list. Those of you involved in these cases will have seen that list, including the deputy minister must state the rationale for believing that there is a substantial risk that sharing the information would lead to the mistreatment of an individual. And that's the language in the guidelines. And then came the statement that begs the question in the guidelines. The deputy minister shall authorize the sharing of information with the foreign entity only in accordance with Canada's legal obligations. And one practical benchmark is given to help ensure a consistent understanding of the risks of information sharing with foreign entities. DFATE will continue to make its country human rights reports available to the intelligence and law enforcement community. So we have a standard to refer to. Then over a year later, when these guidelines were first published and ultimately came out under an access to information request, with a majority government achieved, the Minister of Public Safety rolled out his identical ministerial directives, which are the subject of today's conference, to CSIS on July 28, 2011, to RCMP on September 9, 2011, to CBSA on September 9, 2011. And they follow closely the framework just mentioned and included with materials distributed for this forum. And they warrant careful reading. They are worth spending some time with. Now let me make just 2 observations regarding these directives before turning to our panelists. First, there is defensive information sharing permitted. And it uses these words: information from foreign entities that was likely derived through mistreatment in order to mitigate a serious loss of life, injury, or substantial damage or destruction of property before it materializes. That's the defensive information sharing. And then there is what I call the offensive information sharing, which is permitted. When there is a serious risk of loss of life, injury, or substantial damage or destruction of property, the agency will make the protection of life and property its priority. If the agency needs to share information that was likely derived through mistreatment with appropriate authorities in order to mitigate a serious threat, the matter will be referred to the agency head. All decisions will be made only in accordance with Canada's legal obligations. End of quote. And this is the conundrum that faces our panel. Each panelist will have 15 minutes, and then we'll turn the questions over to you from the floor. Professor David Cole.
Thank you. You graciously referred to all of us as eminently qualified. I consider myself eminently unqualified, coming from the United States, trained in U.S. law, not particularly familiar with the Canadian details, but Francois asked me to talk about the law and practice from the United States perspective. I sat here during the first panel and kind of, getting further and further deflated because for years in the United States, I represented Meher in our efforts in the United States to sue the officials who made the decision to send him to Syria to be tortured. And for years, I pointed to Canada as the ideal. Here's a country that responds to allegations of torture and complicity by holding a major inquiry, by laying out the facts, by apologizing unanimously, by awarding a $10 million judgment. I never forget when we learned that Meher had gotten the $10 million judgment, my co-counsel, who worked for a corporate law firm in New York, their first response to the email was, "Is that 10 million US or Canadian?" I mean, from my perspective, it didn't really matter. It's a lot of money either way, but I guess if you're at a corporate law firm in New York, these things matter. So, but I always held up Canada as the ideal because, whereas in the United States, where we didn't simply provide misinformation, but rather affirmatively made the decision to send him to Syria to be tortured and did so in a way that was designed to ensure that he could not effectively use lawyers to protect him from that design. We lost in the district court, lost in the Court of Appeals. The full Court of Appeals then agreed to hear the case en banc again, which is very extraordinary. We lost there, and the Supreme Court denied review. And he's still on an exclusion list and has not been allowed into the United States to this day. So, so it's a little just deflating to hear how many problems there are here, although I guess you can sort of put them in perspective as compared to the problems that we face and probably still feel pretty good. So I want to talk about the law and the practice regarding the use of torture evidence, and I think it's important to talk about the practice as well as the law because they often differ in significant ways. In the ordinary course, it's established beyond doubt that tortured evidence cannot be introduced in a criminal case. Indeed, that any coerced statement, even if it's coerced by virtue of tactics far below the level of torture, cannot be introduced in a criminal case because they violate due process, the court has said, and because they violate the privilege against compelled self-incrimination. The remedy is to exclude the statement, if there has been a coerced statement, to exclude the statement and any fruits thereof, never to stay the prosecution or to discount the sentence, as was discussed in the earlier panel. That would be unheard of in the United States, although as a kind of informal matter, that may sometimes happen if a case is investigated through efforts that are sufficiently embarrassing to the government may not pursue the case. But as a formal matter, a court would not, has never entertained such a remedy. Outside the criminal context, the rules are less clear because the issue very rarely arises, but the general presumption is that evidence obtained by coercion, by physical coercion anyway, is inadmissible in all civil and administrative proceedings. Generally, it's inadmissible because it's deemed unreliable. So that you don't have to get to the further question. But I think were one to get to the further question, that is, were there a case in which evidence was physically coerced, but there was extraneous evidence that showed that it was actually reliable, courts would almost certainly still exclude that evidence on due process grounds. And the Supreme Court has held, for example, in the immigration context, that while the Fourth Amendment, which is our privacy protection, does not extend its exclusionary rule to immigration proceedings, that is, evidence obtained in violation of one's privacy rights is admissible in an immigration proceeding, even if it's not admissible in a criminal proceeding. The court has said if the evidence was obtained in a way that violates due process, it would be inadmissible in immigration proceedings. I think what it was contemplating was torture. So that's relatively straightforward, but of course, the issue doesn't arise very often in those ordinary cases. Where it arises on a routine basis is at Guantanamo. And there, the law is a little more, the law and the practice is more complicated. So in Guantanamo, there are basically two kinds of proceedings, right, that are involved. There's the habeas proceedings, which assess whether someone is properly detained as a enemy combatant, prisoner of war, as one who was caught fighting for the enemy. And then there are military commissions in which people are tried criminally for war crimes. So in the first set of proceedings, habeas proceedings, they're civil proceedings, they're not criminal proceedings, but nonetheless, the approach has been of the government and of the courts as a formal matter that evidence obtained through torture or cruel, inhuman, and degrading treatment, and of course here there's lots of evidence that has been so obtained, is not admissible to demonstrate that a person shall be detained. And no cases have held that coerced testimony, even testimony that's coerced by some means short of torture or cruel, inhuman, and degrading treatment, is admissible. Subsequent statements from an individual who has been mistreated or tortured are admissible only to the extent that there's been sufficient attenuation that the subsequent statements can truly be characterized as voluntary. That's the formal rule, which I think is makes pretty much sense. But the practice, if you talk to habeas lawyers, is quite different, and it actually reflects some of the practices that were described in the first panel. That is, when a Justice Department lawyer who's defending a detainee's detention wants to create the record for defending his detention, what he does is he goes out to all the other agencies and says, what do you got on this guy? And they present what they've got to him. He doesn't ask, how did you get what you got on this guy? He just wants to know, what are the facts? Is this guy a Taliban guy or an Al-Qaeda guy or not? What do we have that says one way or the other? He then presents that evidence in the return to the habeas as a defense of the detention, and it is then up to the defense attorney in the habeas proceeding to raise questions about, well, you know, this evidence, we have reason to believe this evidence was obtained through torture or cruel treatment of X witness or Y witness, at which point the response of the government is virtually always to claim executive privilege, refuse to confirm or deny whether the individual was, the evidence came from torture, argue that in any event, if the initial source was tortured, there's a sufficient attenuation that the information should come in, and say this is not a formal civil or criminal proceeding anyway, it's habeas, and so everything should be let in and you should just take it into account in terms of weight. So in practice, government officials, at least according to the habeas attorneys, are in fact advancing, not wittingly, but in a kind of blind eye way, advancing evidence that may well, and in many instances has been tainted by torture. Then there are military commissions, very few military commissions, but there have been some. Omar Khadr was involved in one, where the claim is not just that you're detainable under the laws of war, but that you committed a war crime and you can be punished. And there, the original rules provided for the admission of coerced testimony, as long as it was deemed reliable. Indeed, people could be sentenced to death on the basis of coerced testimony. That original set of rules was declared illegal by the Supreme Court, and two subsequent statutes were enacted, and the current rules are that no evidence may be introduced that has been obtained through torture or cruel, inhuman, or degrading treatment, that only voluntary statements of the accused may be introduced, and that involuntary statements from others can be used only if the judge finds that they are reliable, that it's in the interest of justice, and that they were not obtained from torture or cruel, inhuman, and degrading treatment. So the law on its face does as much as it can to keep torture and cruel, inhuman, and degrading treatment evidence out of the case. What's actually going on in those cases, however, is not the government trying to put in evidence of torture and cruel and inhuman and degrading treatment, but the defendants wanting to put in evidence that they were tortured or subject to cruel, inhuman, and degrading treatment, and that should be taken into account in terms of the issues in the case. And there, the United States has done everything possible to keep that evidence out of the case. It has declared classified the detainees' own accounts of how they were treated in the CIA black sites, so that they can't say how they were treated in a public way. If they tell their lawyers can't repeat in public how they were treated. We have basically silenced them to suppress that information. Well, how do you do that in a courtroom? Well, they had to build a special courtroom. The courtroom at Guantanamo is like most other courtrooms. There's where all the participants sit and then where the audience sits, except that there is a plexiglass wall, half a foot thick plexiglass wall between where the participants sit and where the audience sits, and it's soundproof. And the reason for that plexiglass wall is not security. These guys are they're under total control down there. There's no real security threat at this point with respect to what happens in court. The reason is so that if any of the detainees who takes the stand and manages to utter a word about how he was treated, we can shut it off. Shut off the amplifier so that the world does not hear what the world already knows. So what we have is a situation in both the Guantanamo habeas cases and the Guantanamo criminal cases, in which the government is, on the one hand, in the habeas cases, kind of blindly presenting evidence without regard to whether it has been obtained by torture, and putting it on the burden on the government to, or the defendant to raise the issue. And on the other hand, in the Guantanamo cases, where they keep out, they don't use the evidence affirmatively, but they have done everything they can to block the defendant, not only from using the evidence, but from even uttering a word about their mistreatment. I think the issue that Ron opened with and that the directives address is one that I don't think our law really has much to say on. That is, to what extent can the intelligence agencies use information that has been obtained through illegal means? I think the assumption is, of course they can use it. The Zero Dark 30 debate, I just saw it last night, the Zero Dark 30 debate is about whether we got to Osama bin Laden in part through information which was obtained through coercive tactics. That's the debate, whether we did. And some people say, no, we didn't get anything from the coercive tactics. Other people say, yes, we got something from the coercive tactics. But no one questions whether, if we got something from the coercive tactics, we should have turned a blind eye to it in terms of seeking out Osama bin Laden. Right? So when you get, and this sort of goes back to, I think it was Anil's point, that there is a distinction between what happens in the intelligence world and what happens in the courts, where we have very formalistic, formal rules in the courts which are designed to sort of purge the courts of the taint of torture. Sometimes they're not successful, but the principle is there. And then we have the intelligence world where there are no rules. And there's a real question about whether there ought to be rules there, or whether there are other ways that we can respond to reduce the likelihood, given the absence of rules there, that these kinds of tactics will continue to be used when you're facing threats like Osama bin Laden. Thank you.
Thank you, David. I'm pleased to welcome and introduce to you Ray Boisvert, who reminded me just before this panel that several years ago I was his watchdog, and that he was not in Canada at the time of the Mir Arar investigation, so he's not particularly knowledgeable about that case. But with that, a very warm welcome to you, Ray, to share from us the perspective of a former CSIS intelligence officer.
Great, thank you, Ron. First, allow me to begin with a couple of basic statements or fundamental beliefs. Mistreatment is, of individuals by a state, abhorrent, and it must be condemned through both actions and words. Secondly, the information derived from torture is at best, in my view, unreliable. But having said that, let me give you a bit of the sense of the practitioner view, and I'll walk you through some of the issues that I've faced as a senior manager at CSIS over the last 30 years. One of the things that's been most challenging is understanding the provenance or the sourcing of that information. However, it's not the only and the most significant challenging aspect relative to maintaining this sort of principled approach to intelligence management. For example, is the information at hand the product of mistreatment? And if so, what does one do about it, particularly if it's purported to contain threat-to-life information? One thing I do know from over 30 years of practice is that Canadian officials must engage with foreign states and entities in order to execute their respective mandates and responsibilities in the service of Canadians. It's all about facilitating commerce, defense, travel, immigration, and other matters. The idea of picking or choosing to engage only those you like or those you respect is not really a viable or sustainable approach that will lead to any success by, I believe, any particular measure. Again, very practically speaking, and from my experience, Canadian passport holders have traveled to places like Pakistan and to Somalia, just to name two rather complex areas for us to manage information sharing. And yes, let me state unequivocally, they're also there with the intent to do harm to others. Maybe not the Canadians necessarily, but in my business, that doesn't really matter. When I was the DG of the Principal Counterterrorism Branch, we engaged in investigations of extremist activity both at home and abroad, and there was seemingly not a day that went by that my deputy and myself were not sitting in the office and looking at each other and saying, here we go again, it's another day with another serious threat to life, bit of information to manage, or serious corporate jeopardy for the organization or the Government of Canada. All of which, of course, having some serious consequences. In one case that came to mind the other day as I was preparing some of these notes, again, my favorite deputy came in to see me and we sat down and he said, here's what I have. And this is about 6:30 on a Tuesday night. We have two Canadians who just exited the country within the last 48 hours. They left clear communications that they were aligned and believed to be ensconced or believed to be deep followers of a very well-known Middle Eastern cleric and extremist. He's admonished them to engage in violent jihad, and he's been particularly successful in convincing the young woman to become a suicide bomber. And they are believed to be on a quest. So, staring at him directly in the face, I say, well, okay, so we have two young persons. They've just left Canada. They made it clear where they're going. And we know quite clearly what they're going to do at the other end once they arrive. And they have 2 days advantage over us. They're traveling, moreover, through a number of countries which are not, let's be clear, Sweden or Norway. At the end, they'll end up in a country which has little in common with Canada in terms of values or otherwise, and they'll be targeting innocent persons at the other end, absolutely. I guess the easy principle approach of sorts is we could have stepped back, we would have weighed the moral and legal implications and obligations, and we could have concluded that it's best not to violate any principles of information sharing, and that if we do that, nobody gets in trouble. And of course, though, if there is any bloodshed, it won't be involving likely Canadians, so therefore it's not our problem. Well, thankfully, that's not the way things work at CSIS, and that's not simply the way people look at the business, I think, in most Western jurisdictions. It's not what the majority of Canadians would expect from their institutions, and those institutions they've funded and they've empowered to ensure that they can go about doing their business safely, securely, and also us extending protection of human life to all. So let's also remember that over the last number of years, there have been a number of Canadians that have been kidnapped in places like Iraq, Afghanistan, Somalia, Pakistan, Niger, and Sudan. I worked on several of those cases over the years, and I can tell you that they're not easy for us to operate within, and they're just as complex as that previous scenario about information sharing. To resolve these crises, service officers and other Canadian agency representatives, often working on the ground in the most hostile environments, where few, I would say, would dare enter, had no option but to engage emerging or challenging partners in order to gain some sort of insight or intelligence with respect to those individuals who are detained against their will and to find some way which eventually, and it did in all these cases, lead to either their rescue or their release. So let's just say it is clearly not an easy business to manage. So here we go. We have a number of intersecting interests. We have a number of principles that clash in many ways, even though they're not, I think as Anil said, they're not mutually exclusive, but they are nevertheless quite challenging. We have Canadian interests in these last two cases or examples, including those involving kidnappings, that intersect with states that have less than, shall we say, a stellar human rights record. We're definitely not talking about travel to Iceland or Costa Rica. So when I look at those, and I look at the way that services, intelligence services particularly, have to exchange information, it becomes a deeply complex and a very difficult thing to manage. In fact, I wonder if any of us in the room, if we think back, and even quite often I reflect on those many sleepless nights, if we sat there and simply looked at all of the UN member nation states and took a list of almost 200, I think 193 currently, and set aside a ledger of which countries we believe which would be somewhat problematic or complicated in terms of sharing information for a number of reasons, in terms of how they value, how they share principles, and so on. I suspect that the left side of our ledger, we'd be left with 10, 20, and perhaps 30 countries that we could see as being without any cause for concern. So is there complexity on information sharing in an interconnected world? The short answer is absolutely. It's the age of globalization and connectivity. It's a place where Canadians and Canadian interests take us to every part of the globe, whether it's for aid delivery, energy exploration, or even eco-adventure tourism. And thus, Canadians do rely on their institutions to keep them safe, as I said, secure, and not simply to come to rescue them after the fact. I learned very early in my business that failure to meet those expectations have indeed some very serious consequences. Assets do become or fall under severe threat, and there is that potential for loss of life. More importantly, though, or as importantly, there's another side of that coin of negative outcomes. And I'd suggest that it involves a level and a kind of scrutiny that I think a lot of people in this room would shy away from. I've testified on all the security certificates. I've been involved in various inquiries, and I can say that trying to explain to a commission or to a judge why you fail to act is as difficult as explaining why you acted in a certain way. And in fact, I think the former would be far more difficult to say that you failed to execute your responsibilities effectively. So to be clear that when I'm talking about these sort of complexities, I want to ensure that in those types of positions that I led, those types of decisions, I always had Canadian interests first, and that all of that involved to be able to provide, whether it's Canadian businesses, Canadians traveling, whether it was a case of Canadian officials operating overseas, they needed to have some measure of assurance, and the only way to do that was to have an effective information flow. And to be clear, it is unstoppable. The world is connected, information, people, travel, and there are needs to share information about individuals. And I guess I go back to Anil's example of Agency A telling a Canadian official that so-and-so is a potential threat, and that in itself causes at least a moment of pause and consideration. So I will suggest to you as well, though, is that it all involves risk management. And we talk about risk management. Most businesses have evolved in a way that managing risk has become the way that we can ensure profits and that we can ensure that there is effective operations. Government has adopted those same principles and approaches over the last 10 years to be much more efficient, effective, and more relevant to Canadians. So this, however, brings it down to a level that's unprecedented in government because it affects people in very real ways at both ends, from either those who may suffer mistreatment at the hands of others if the information is misused, or at the other end, if information is not used effectively, people may be killed or kidnapped or tortured by persons other than the state. So what I felt is that in these sort of situations, there's a number of things that must be clear, made clear to ourselves within the institution that I worked in at the time, and I would suggest to Canadians as well. We must be mature about these things, we must be realistic, we must be competent, and we must be confident. We shouldn't just blindly adhere to a doctrine of moral high position because I believe in some ways, in many ways, it's actually unsustainable in a modern world. We also need to be equally critical. We have to think critically about these topics. And we must recognize if we fail to engage, we won't necessarily provide a higher level of assurance that people will not be subjected to torture. So one of the best approaches, in my view, based on my own personal experience, has been to effectively engage with states who do have a less than stellar human rights record. Because in doing that and following that strategy, we can ensure that Canadians and Canadian interests remain safe and secure, and the Canadian values are protected and are projected outward. So one way to do this, I believe, was to develop a series of rules of engagements for its officials. And in my view, Canadians should, in some ways, take some pride in that, and that Canadians and Canadian institutions that represent Canadians have actually learned a lot of lessons over the last 10 years since 9/11. We have to also, I think, when you look at the ministerial directive, which has been the subject of this discussion, or should be the subject of the panel for today and this next session, is that absent ministerial directive, intelligence service and others will occasionally run amok. We saw it in the 1970s during the FLQ crisis, wherein the RCMP security service, the predecessor organization of CSIS, was essentially judge, jury, and executioner. They defined themselves who was a threat, they defined how they would investigate it, and they took whatever action they felt was necessary. So as a former practitioner, I do welcome the ministerial directive. Having said that, I recognize as well that it's not a panacea. Part of the problem is that intel businesses deal with information, and it's big data. It's a lot of it. It's coming at them through a lot of different methods. It's very much akin to somebody working on Wall Street, or perhaps a lawyer dealing with full disclosure on a complex investigation. Most times there's too much information. Almost all of it is rather opaque. It's piecemeal, and it's also dispersed. Sorting it out, in other words, what's meaningful, what's actionable, what's a distraction, is now, through this MD, forefronted by another principle, which is what's tainted by mistreatment. But let me say that agencies, nevertheless, will remain severely challenged by this reality. Executing their mandate, understanding what could happen at the other end should they not apply their tradecraft at the highest level. But part of the challenge is that also that continue despite all these invocations of different rules is that how do you decide if information provided by agency X is exclusively their information? Was that information from country X tainted in some way? Does one disregard it, as Anil said? Do we attempt to corroborate it? Do we park it, or do we simply destroy it? And if we do that, do we do so at certain peril? At CSIS, while I was there, as a reaction to the concerns over the issue of human rights, there were a number of assurances and a number of steps were brought forward to try to best mitigate those processes. And the MD reflected that, and CSIS reacted as well to that MD. Obtaining assurances from agencies was key. Verification and reporting of systemic and specific challenges on human rights fronts, in other words, making sure that officers at the front line knew about which agencies were potentially problematic, and to challenge those agencies on their practices. Also, we had to invoke procedures on how to contain, mark, restrict, and use information in certain ways if we believe they were suspect tainted by torture. Moreover, and through an ongoing approach to CSIS, they worked very carefully at working with suspect agencies by making them understand that there are consequences if you engage in mistreatment. Some of it involved isolation of the agency, reduced, suspended dialogue with those agencies, and also the elimination of exchanges of information. Conversely, we often insisted on training with respect to democratic principles and fundamentals, the rule of law, appropriate definitions of threat, and proper investigative methodologies. And typically, we did the very Canadian thing. We admonished them daily about the right ways of doing things and holding both the carrot but also the stick. I'd suggest, despite all those efforts, by trying to ignore this problem, by vacillating or pretending that bad things will just eventually go away is not really sustainable, as I hinted at the outset. If we don't engage, if we don't exchange information, tragedy will indeed strike. People will die, and I believe they will continue to be subjected to torture, something that Canadians should not stand for. So let me conclude by saying that I strongly welcome the MD. I recognize and respect the role of officials must play in maintaining the highest standard of propriety while effectively protecting Canadian values outside the country. But equally, I understand through direct experience that information must flow despite the complexities. And despite how uncomfortable some of the wording may be in some of those ministerial directives, I do feel that at the end of the day, they will provide the right kind of framework to ensure that people will do the right things, that they understand the rules of engagement, and that they will be held to account should they fail in executing their mandate effectively and at a proper level that continues to ensure the respect of Canadians. I'll stop there.
Thank you very much, Ray. Professor Kent Roach, University of Toronto.
Thank you very much. I'd like to thank the organizers, and particularly Francois, for organizing such an important event. One of the first things I want to say is that, this is a panel on the executive and on ministerial directives. And I think one of the important things about national security law that Ron teaches and I teach, a few of us teach throughout, is it really does focus on the executive. It isn't that the courts don't have any role to play, and I'm going to talk a little bit about how the Suresh exception influences the ministerial directives, but the court's role is after the fact, years after the operational decisions have been made. And so I think it is, very important for us to take ministerial directives, or, another version would be the John Yoo, JBB torture memos. Those weren't a judicial decision. They were an executive interpretation of what the law allowed. And so, I think it's a positive that those memos and the ministerial directives are now in the public domain. They're not in the public domain as a matter of course, but in order to understand national security, you really do have to focus on the executive. And that was one of the reasons why Justice O'Connor, in the Arar Commission report, spent so much time on review of the executive, because although Justice O'Connor is a judge and a former litigator, he realized that the courts are only going to see the top surface of what actually happens in national security. And when they do see it, they're going to see it on a time delay of many, many, many years. And so that's why, as difficult as it is to get information about how the executive is either interpreting legal restraints or acting in a lawless way, that's really critical to understand what is done to protect us in our name. Now, having said that, the directives that we're talking about today do reflect the Suresh exception. And I think it's important to be clear about what the Suresh exception is. I think it's in paragraph 78 of the judgment, which comes right after 9/11. And what the Supreme Court said is it will generally violate the Charter to extradite someone to torture, but we're not going to say never. We're leaving open the possibility that in, quote, exceptional cases, deportation to face torture will be consistent with the Charter, either not violating Section 7 or upheld as a reasonable limit under Section 1. Now, that exception has never, to my knowledge, been openly endorsed in a particular case. And so you might say, well, why have people like me spent over 10 years now making a cottage industry of criticizing the Suresh exception? Well, one of the reasons why I think it is important to criticize the Suresh exception is it is, in a way, a loaded gun that the court has given to the executive. And you see echoes of the Suresh exception in these ministerial directives. And it's important to know that other courts who have looked at the Suresh exception have said, no, we don't want to go that route. The European Court of Human Rights was asked to embrace the Suresh exception. It declined. If you read Justice O'Connor's report on the right to torture, there is no mention of the Suresh exception. So I think it would be good if the Suresh exception went down into the dustbin of history, and it's not applied by the courts, but it's very much alive in the hands of the executive, and we have to be vigilant about how it is exercised. Now, I agree with Mr. Boisvert that we need to share information, including with countries with poor human rights records. There's nothing in the Arar Commission that says information should not be shared with countries with poor records. That may be a popular misconception. It might be a way to try to discredit the Arar Commission, but the Arar Commission recognizes that information sharing, and it has to be a two-way street, is of necessity going to happen with countries with poor human rights records. But what the Arar Commission said was, if you're going to do that, you need at least two things. One, you need adequate controls and training and accountability measures within the executive, within CSIS, within CBSA, within the RCMP. That's one, but that's not enough. Two, you need independent review by watchdogs within the executive who can see the secret information in real time. They may not be able to publicize what that information is, but you gotta have a third party who's sitting outside of the day-to-day pressures of protecting Canadians who can see what is happening. Now, the ministerial directives are a good first step, and indeed the Arar Commission praised and asked for more ministerial directives. There's a lot of good things in those ministerial directives. The idea that as the risk increases, so should the level of accountability and executive control and the seniority of who signs off, that we should look at what DFATE says about what a country's human record is. That's all good. Now, one of the reservations, though, that I do have is that although those ministerial directives do say that if we're in the torture zone, it's got to go up to the head of the agency or the DM. And I think that's appropriate. But what about ministerial responsibility? Do we still believe in ministerial responsibility, or do we just think, well, that's not going to happen? What about, because there is a discretion in the directives that the head of the agency doesn't necessarily have to inform the minister. But for me, the most troubling omission in the directives and the most troubling omission within the executive realm is we don't have the effective third-party review within the executive about how these ministerial directives are operated. So there's nothing in the CSIS directive that says if we're in the danger zone, getting involved with torture, either a risk of torture, sending information out, or information coming in, we have to tell the Security Intelligence Review Committee, which Ron Atkey was the original chair, we have to tell them about that. Why isn't that within the ministerial directive? Maybe CERC will know about that, but CERC is, I think, a beleaguered agency. The Inspector General, who was a watchdog about the legality of CSIS's action, has been just completely abolished by the government. Few more people have gone in to CERC. They've lost their executive directors, retired. Why isn't there that sort of alert? Then Tara McElroy told us about CBSA. She told us about CBSA agencies who've never looked at DFATE advice on human rights, who've never heard of the U.S. Secretary of State Human Rights Report. Who reviews CBS? Nobody. Nobody. There's no federal ombudsman, there's no CERC, there's no RCMP, it's just the minister and maybe Craig Scott on a parliamentary committee. But the parliamentary committee is not going to be able to access secret information. Everything is secret. You cannot do review that is credible without having access to secret information. We can have fights and we can have disagreements about overclaiming a secrecy and what goes out, but you just can't do review. So CBSA is kind of a, what, a lawless zone? It just has the ministerial directive, and I guess we just have to hope that the person in charge of CBSA does the right thing. Then it comes to the RCMP, which is also subject to the directives. Justice O'Connor recommended that the RCMP Complaints Commission should be able, as of right, like a public inquiry, to see all of the secret information, see everything except cabinet confidences. The government in Bill C-42 has said, no, we're not going to do that, and the RCMP Public Complaints Commission can get into a fight with the RCMP about access to secret information, and there's a provision in Bill C-42 that says we'll then appoint a retired judge who can decide or can come up with some sort of decision which doesn't even seem to be binding. So it's very important to realize that these directives go to CBSA, RCMP, and CSIS. Government, quite rightly, because of the security threats that we face, is taking a whole of government response to security. Again, the Arar Commission had appraised that. Governments across the world are doing this. But the problem is that review is not catching up. Review is in a silo. The RCMP Police Complaints Commission cannot share, they may not even have access to secret information. If they got access to secret information, they couldn't walk it down the street and share it with the Security Intelligence Review Committee. They could not conduct a joint review. So I would be much happier with the ministerial directives if we had an adequate review system, whole of government within the executive. Now, the last thing I want to say is this distinction, and I think that it is a valuable distinction that Ron Atkey made about the defensive and offensive use of information that may result in torture. If you look at the directives, and I think so far most of the examples that Anil and others have put forward have been about the defensive use of information. That is, Syria, Egypt, whatever, Pakistan says that there may be a security threat. I don't think anyone really that lives in the real world would expect us to ignore that information. If there's information that comes in from a country with poor human rights record that a bomb has been planted on the Toronto subway, I think that we're going to, step up our vigilance on the Toronto subway. But of course, that defensive use, I think, is relatively easier for us to control the issue of complicity. One, if there has been torture, it's already happened. And two, we can say thank you very much, but we don't necessarily have to send messages of encouragement or even condemnation to the country that has given us the information. The other use, though, is the offensive use of information that may then result in a substantial risk of torture. This is not an academic issue. CSIS and the RCMP sent questions to Damascus that were used by those who were torturing Canadians in the far Palestine. To me, that offensive use is far, far more problematic. I think morally, if we send questions, we're morally implicated if a person is beaten in order to get those right answers. And that's why I think it's quite shocking that these directives, although they focus on the defensive, and people who will defend the directives will say, well, of course you don't want us to ignore information that's going to lead to something going boom. Ignore and don't look at that offensive, given the findings of both the Arar and Yakabuchi commissions, that sort of information sharing with Syria has led to the torture of Canadians. And to me, that's just a regrettable erasure of relatively recent and, as David Cole said, history that Canada could have once been proud of. The directives are written as if that had never happened, and I think that is regrettable. Thank you.
Well, thank you very much, Kent. That was a very useful contribution in putting the icing on the cake on this panel. I have a couple of questions I want to direct to the panel generally. The one stems from Kent's comments about the role of the courts. In your observations, both the United States, David, and Ray and Kent, in the Canadian context, do you see the courts taking a more activist role? And I'm not talking about the Supreme Court of Canada, which ultimately must decide the difficult cases, but more important, the designated judges of the federal court and the occasional judges of the Superior Court when they're hearing criminal cases that involve security intelligence evidence. Do you have any observations on the role of the courts in this whole conundrum, which I've called it? Because after all, the courts ultimately do interpret and in some cases decide what the law is. Kent, why don't you start? That's the lawyer's question.
Sure. Yeah. I mean, certainly. One of the interesting facets, I think, globally of post 9/11 is before 9/11, courts had a very regrettable, very deferential record on national security. I think whether it's Boumediene, whether it's Belmarsh, whether it's Sharkawi, courts have been much more active. And I'd be very interested in Ray's views about Sharkawi 2, which I actually think, although it wasn't a charter decision, really kind of shook CSIS's world and operating procedures that they had proceeded with since 1984. So yeah, I mean, I like a good court case as much as the rest of the room, but I would go back to the fact that the courts are only going to see the very tip of the action and on a huge time delay. And so I worry that the activism of the court is curbing our demands for effective parliamentary or executive watchdog review. So yeah, I mean, the Supreme Court of Canada's said some relatively impressive things, but it's not impressive that we're the only parliamentary democracy that doesn't let parliamentarians into the ring of secrecy. I mean, geez, everyone's got a security clearance in Ottawa, but the parliamentarians, unless they're part of the Privy Council, Privy Councillors are not within that ring of secrecy. So yeah, I mean, the courts can play a role, and I think that in the Suresh decision, there's been cherry picking of some of the worst parts of that decision. But in a way, I don't think that's where the action is in national security.
Ray, before you jump in, just a background checkup or catch-up here is Sharkawi 2 essentially says CSIS officers in their investigation have to retain their notes for time immemorial, and it's been called the over-judicializing of security intelligence by the current director.
Funny, the words I wrote down as a reminder, judicialization of intelligence was going to be the lead statement, absolutely, and not inappropriately so. I think that transformation was very useful because it just reflected what the reality is of the day. And let me just take you back in history a little bit. CSIS was created for the very reasons and for the very sort of activities that it's now currently being asked to do. So let me try to explain that better. The RCMP security service of the day, as I said at the outset, ran amok. And there was this deep concern about having intelligence services doing law enforcement type of work. In other words, collecting evidence. So we created a civilian service whose job was to strictly do the collection of intelligence, do the assessments, and give advice to others so they can take whatever action they felt was necessary to deal with the threat. So up until 9/11, the biggest chunk of CSIS was still actively involved in counterintelligence. And those assessments and those decisions and those outputs were basically to say that we believe that Yuri is a suspect or known intelligence officer. it mattered only to us. It mattered to nobody else. Fast forward into the big world of counterterrorism post 9/11, and that intelligence was collected, was now being held increasingly, and as demonstrated through the challenge of security certificates and other sort of judicial processes, to a standard that it was never designed to survive through. And that became a big, big wake-up moment for everybody. And of course, Charcuterie too added to that in terms of the reason why evidence was destroyed up to that point, because that was the doctrine that was drilled in when I first arrived in 1984 as a very young officer, was we're not in the evidence business. If we retain the stuff, we can get people in trouble, because we're holding information that may not be necessarily important, and it will just cast aspersions on others. So the whole process was designed to destroy information because it was not evidence. And that caught up.
And the law said you could keep that intelligence only as strictly necessary, and that's the law of the land.
In the U.S., I would make this observation. I think that the courts are pretty good about ensuring that their processes are not tainted by torture. So, keeping stuff out of the process, so we keep the judicial process pure. They're they're good at. I think most judges are very troubled by the notion that any evidence would come in that would be tainted by torture or even physical coercion, and so they're pretty good about that. It's often hard to know whether the evidence was actually obtained through physical coercion or not, because it's one person's word against another. But on that, they're good. What I think they're not particularly good at, and what they have not been very aggressive at all about, is holding people accountable after the fact, where there is clear evidence that government officials have engaged in torture. And that's the Arar case is just one of many, many cases in the United States where victims of torture, where there's really very little dispute about the fact that they were tortured and that U.S. officials were involved in the actual infliction of the torture, the authorization of the torture, the sending the person to torture, in which courts have refused to hold those officials accountable. And so I'm struck by Ken's suggestion, which is we got to put essentially court-like review into the agencies, right? This oversight process looks a lot like what we generally think of courts doing with warrants and the like. But since courts aren't doing it, create some entity within the agency that's more likely to take it on.
David, I have one question for you as our visiting American guest. When is Guantanamo going to close?
I don't think, I think that's a rhetorical question, so maybe I don't have to answer. I mean, my sense is that President Obama very much does not want to leave office 8 years after having entered office, promising to close Guantanamo on his first day, with Guantanamo still open on his last day. That said, and so I have some reason to believe that at some point he will turn to this. That said, at this point, I mean, up till now, he has not turned to this. He has had other priorities. It's not really his fault that there are the blockades are imposed by Congress, by Democrats as well as Republicans in Congress, who have a kind of not in my backyard approach to this whole problem, and saying the last thing we're ever going to let happen is have a person held at Guantanamo be brought into the United States, into my district or my state, even though that's what's necessary to close Guantanamo. But I do think that President Obama could change that if he took it on as a priority, and I'm hopeful that at some point he will.
Isn't one of the sticking points that the person must be returned to their country of origin, and that Omar Khadr was one of those sticking points? That issue has now been solved. He's back in Canada. How many others are there that cannot be returned to their country of origin?
There are many that can't be returned. I mean, there's basically different groups of people. There are some people who we just don't think we have to release or want to release. Khalid Sheikh Mohammed, take Khalid Sheikh Mohammed. Even if for some reason his war crimes prosecution does not go forward, he's not going to be released. as long as there is an armed conflict with Al-Qaeda. You don't let go the number 2 man in the force you're fighting against as long as there's an armed conflict. So those people will be detained, period, and they'd have to be detained in the United States. Then there are a bunch of people who've been cleared, who we at this point don't believe need to be detained. Maybe they were never properly detained, maybe they no longer pose a threat, but we can't return them to the country from which they came because they face a risk of torture. So we have an ambassador for the closing of Guantanamo, whose job it is to try to go around and encourage other countries to take these people. But of course, other countries aren't real eager to take these people when we're not willing to take any of them. Even the ones that we've cleared, we're not willing to take. And then there's a whole group that are, in particular, of Yemeni who have been cleared, but were insufficiently satisfied with the security situation in Yemen. And the concern is if we send them back to Yemen, they'd be, shooting at us immediately. And so until the Yemeni situation gets straightened out, we can't do anything with them. So there's a, there are blockades with, there are, significant problems with many of these people, but at the end of the day, I think the biggest problem, the most intractable problem, is Congress's unwillingness to have them in the United States under any circumstances.
Thank you very much. I think it's now time to have each of you join this interesting conversation. Amir, do you have questions you'd like to ask? I saw your hand go up.
Thanks. Thanks, Ron. Two questions for Raymond Boisvert. One, before you do make a decision to share information, is a legal opinion sought on whether doing so would comport with Canada's obligations vis-à-vis torture, and whether doing so would comport with the Privacy Act? So does it actually go to legal counsel before the sharing is done? And two, repeatedly during your talk, you said that the justification for information sharing was that we live in a globalized, connected world. I'm very dubious of that. I mean, terrorism was with us a long time ago. In the Hellenic era, in the 12th century, Fatimid Empire with the assassins, with Guy Fawkes in the 17th century, you may even say with Louis Riel, right? So why is it that the world is different now? Globalization has been with us before, and terrorism has been with us before.
Sure.
And then to Kent, one question, please, Kent. Hi. Is it your view that Suresh is ripe for revisiting since the HAPE decision? Because, of course, HAPE brings norms of international law into not just our common law, but our charter as well. And the prohibition on torture is jus cogens. How would that change it? Is it time to relitigate it on that basis?
I'll deal with your second question first, if I could. Certainly, like you, I'd hesitate in identifying Louis Riel as somebody who would classify as a terrorist like you. I don't think we disagree on that. But I think I was saying half jokingly, but otherwise, it's more a case of the nature of conflict has changed tremendously. So although there has always been sources of subversion and violent conflict internally in various states through history, at the end of the day, interconnectivity has made this a globalized event. So what happens to say that say that an event and a terrorist attack occurs in isolation in downtown Toronto, it might happen one day. I think there's enough connectivity quite often to the stimuli in the first place in terms of who gave them the ideas, what was the initial force behind their reasons to wanting to get involved in attack planning. And there's also the issues of training and provisioning and so on that happens on a large scale and happens involving a lot of countries. So as a result, and it goes back to my example, those two young persons who leave this country and they're off, and this is more a case of offensive sharing, and I don't disagree with Kent said about there's a way of managing things through defensive and offensive perspective. Offensive gets very, very challenging, but sometimes it's going to be a necessary evil because we have two people who are going to go out and kill people in another country. and they're traveling through a whole bunch of other countries to get there, what do? Do we try to stop them? And if we do, which countries do we stop them in? And our decision making was always about, well, let's try to get them stopped in a country where we can at least have shared values and find some way to get them a fair trial or get them returned to Canada safely. So that probably brings me to your first question. There's a whole framework that was structured or created over the last number of years, and it's based on a threshold. And it looks at everything from geography, geopolitics, it looks at the legal framework in various countries. There's an entire matrix, and officers need to consult those as they move forward. And hopefully we've hired a whole bunch of young, bright people who know that Costa Rica is very different from Yemen. Although there are some complexities in Costa Rica, it's not the same. So there are those little factors. There are litigation teams that were created, involve intelligence officers and people with legal backgrounds or practicing lawyers. And there's also Department of Justice lawyers who are on board. And there were very few decisions made at the desk officer level, very, very few. We tried to empower people and give them discretion in order to do the work they need to do. But when it came to this issue, the level of approval was very, very high.
But in that SOP that you have, must you go to legal counsel for sharing, yes or no?
Depends on which country and what kind of issue, what kind of persons, and what was the, what sort of information. Are we talking defensive information coming in, or are we just talking about information going out? So information going out, it comes down again to a matrix, and it comes down to seeing where the risks are. If the risks even inch anywhere towards a higher than any sort of level of jeopardy corporately or in terms of risk to life, including torture, it had to be raised all the way up, and quite often legal counsel were brought in on the old difficult cases, or anything where there was a high threshold of risk.
Amir, my observation through the Arar inquiry and more recently in other cases is that when in doubt, kick it up to the deputy or the agency head and get the advice of counsel, who's usually a justice lawyer assigned to the particular case. And that it's not mandatory in the directive, but it's when it's evidence of mistreatment, it's in the so-called danger zone that Ray mentions. The general practice has been, and the Security Intelligence Review Committee is supposed to oversee this vis-a-vis CSIS, is when in doubt, kick it up to the deputy and get counsel. One other aspect of information sharing, and I want to give you an anecdote that Kent may want to comment on. Our worst terrorist act in Canadian history is Air India, 1985. And that's an act of terrorist which killed a couple of hundred Canadians. There was not full information sharing either internally in that particular context, and there were several commissions, including the one Kent worked with, that looked at that, but also there was an absence, and I was on the Security Intelligence Review Committee then. We were struck by the lack of detailed information that went back and forth between India and Canada about particular persons that were living in the west coast of Canada that were part of the Sikh community that were seeking to create a separate state of Khalistan. And so that's one instance where perhaps information sharing might have helped and might have prevented what has really become a major Canadian tragedy.
You asked whether CSIS might be reconsidered. I hope so, but I'm a bit pessimistic. I mean, the CSIS exception, of course, was pure obiter dicta because CSIS was not going to go back to Sri Lanka. You really wonder why. I guess future historians will have to find out why that paragraph was inserted. Of course, you're right about HAPE, but the problem is that in CSIS, in a perverse way, you got to praise the court for its candor, is they said, look, if we deport someone to torture, we recognize that that violates international law. It just won't violate the charter. And so, perhaps you can read HAPE as constitutionalizing certain international law principles, but the fact is, as Craig mentioned, that they ducked the Afghan detainee case and another case suggests that there's not a lot of eagerness to revisit the CSIS exception. And I worry that the court feels that they're off the hook because it's not being used by courts, right? But that's not the point. The point is that much of this happens in the executive, and even in the security certificates, it is held as a reserve position. So the primary position is no torture, but the residual position is the CSIS exception. Ron mentioned the Air India India. And I have to, go back to something because I worked on both Arar and Air India. And especially during Air India, as Anil and others will know, I was haunted by something that the late Jack Hooper said, who you probably worked with, and who I never had the pleasure of meeting. And he said, Arar is going to tell us not to share information, and Air India is going to tell us to share information. And I don't know whether I was successful, but over the 6 years that I worked on the two commissions, I made it my personal mission to avoid that sort of critique. And at least from my biased, jaundiced eyes, I think if you go back and you read both of the reports, certainly nothing that Justice O'Connor says that we shouldn't share information, but that we need to have both the constraints within the executive and the independent review. And similarly, in Air India, there were, issues of possible torture on information sharing. But one of the things that the Air India Commission recommended was that, there needed to be a safe place for this intelligence to be shared and for someone within government to make a decision in the public interest about what should be done with that information. And the Air India Commission even went so far as to say we should even have a new privilege to ensure that there's a safe place while this information is parked. But again, the government's ignored both of those commissions. And I think that, although there's differences between those two commissions, both of those commissions were saying that our review structures, whether it's for propriety or efficacy, have to catch up with the whole of government transnational nature of national security. Government is doing this for legitimate reasons because of the nature of security threats, but we need to make sure that those who mind the watchers also have that same flexibility. To me, that's what unites the two commissions of inquiry. And, unfortunately, this government, although it accepted Arar Part 1 and gave Mr. Arar $10 million, has basically walked away from all of the policy recommendations of either the Arar or the Air India Commission, which were all, really about reforming the executive. It wasn't waiting for some kind of judicial fix. And I fear that if we don't reform the executive, the courts are, not going to save us or only save us in a very small percentage of cases.
Thank you, Kent. Barbara Jackman, new question?
I just have 3 short points to make. One, Kent, the federal court has in fact used the Suresh exception. I think if you cite up Justice Shore, Somalia and Suresh, you'll find that he decided that a young kid could go back to face torture in Somalia. I don't know if that kid was killed, one of them was, but I'm not sure if it was that young guy that was killed. But there's no analysis in the reasoning, really. He's got criminal convictions, there's exceptional reasons to remove him to torture. So it has been used once, and It concerns me with the climate that we face right now in the courts that it will be used more often. The other was just, I think it's important to explain the second Sharkawi to the context of it. In these hearings, people are being asked, like Mr. Jabal or Mr. Majoub are being asked to answer. They're given evidence that's a summary of evidence, not the original transcripts of the intercept, saying, you had a conversation with Mr. X, you don't know who it was, on August of 1996. And he's supposed to answer whether he challenges that. There was a reason. If you're going to use intelligence information to detain people and deport them to countries where they may very well face torture, you've got to have the evidence and allow them at least to challenge it. It's not just out of the blue that the court said it. And then the third point was also in response to you, Raymond, was the concern about the person going overseas who may end up killing people. We have clients, I have a client who's brain injured, who, if he goes overseas, may very well kill someone. He's already raped someone. And he doesn't have the ability, he doesn't have impulse control. He's brain injured. He's not a criminal, he doesn't have a criminal mind. He's got the mind of a 9-year-old without impulse control. We have no concern about setting him off in another country. Like, there's a real disconnect there. If we're so worried about everybody else, why don't we worry about everyone else when we're worrying about who we're removing from Canada?
Any comments?
Well, I could perhaps on the last example, an important one and one well said and clearly popular. It's really a case of the service will only investigate those persons whose activities present a threat profile, where they've done something, they've engaged with others, or they've demonstrated they're willing to do something. In this case, it's an individual having this lack of ability to control oneself and could theoretically do something is an entirely different issue, but point taken.
Question here? Yep.
Hi, my name is Burton. I'm a student here at Osgoode. I have a comment for Mr. Boisvert. You're speaking about the cost of intelligence failures. And, I mean, it would be very obvious for all Canadians if there was a false negative and there was an attack. But I was wondering if you could comment on false positives, if there were people who were innocent, who were captured, and how CSIS addresses that, and how Canadians would be made aware of those failures.
In terms of false positives being information that caused an overreaction by government or by government agencies?
Well, you know, if you have intelligence and there's a false, you know, if you think something is not a concern and there's an attack, right, Canadian CSIS would all be aware of it. Mm-hmm. But if there's someone who was innocent, who was in prison before an anticipated attack, right, how would CSIS or Canadians be made aware of those failures?
Mm-hmm. Well, again, I guess there's a distinction made between what the RCMP and the law enforcement piece would do in terms of prosecuting somebody or working through CBSA and detaining somebody under IRPA and having them removed, for example. If there's information that is found to be flawed, if it's found to have been derived through mistreatment, or if it's just simply found to have been less than accurate, that has emerged through these processes of review, and that's why I think I've welcomed, as I said, I testified in all those certificates. It was a most difficult process, and there's a lot of scar tissue on the numbers of a lot of persons, including my own. There were a lot of lessons learned, and I think it also aired or provided the right kind of light on the amount of information was on the table to say whether or not this person was actually a national security threat. The larger issue of getting it right or getting it wrong in terms of assessments is a really difficult one. My last job was the assistant director responsible for the knowledge piece. What we know, what we don't know about threats, where are the gaps, and how do we drive the collectors to go get things that we don't know much about. And of course, then turn that into usable intelligence for agencies like CBSA or DFAID or D&D or the Prime Minister's office so they could either set new policies or take whatever executive action that's required. My biggest fear, and where I drove home day in, day out with my managers, was the worst thing we could do is get people to overreact, is to get the assessment in a way that's so alarmist that would cause people to do things that are completely unnecessary. Not only is it a waste of resources, but it's just horrible corporate jeopardy for us to manage. And we will all hang together, and justly so. So there are a lot of internal checks and balances within the system, and people know that assessments, what you say, isn't, as I said earlier in my 1980s example, when the assessment came out saying that Yuri is an intelligence officer, it mattered to only us. And maybe we would tell DFAID, and they may decide that his activities are incommensurate with his duties and that he should be punted out of the country. Sometimes that happened. But in this new world, this post-9/11 world where there are individuals who are detained and they're subject to potential removal from Canada and facing unknown outcomes, that's serious business. And as a result, I think the systems are calibrated to make sure that it's done right.
Thanks very much. We have two questions, Francois Tanguay-Renaud and then Colin Freeze.
So let me show off a little bit. I teach here at Osgoode, and my students are very bright. I have very bright students. I teach public law, criminal law, and sometimes at the beginning of the year, I ask basic questions to my students about our Canadian system, how it works. You know, what's a federation? What's the role of the Senate? Who's our Prime Minister? Who's the Premier of Ontario? And the answers are surprising, right? A lot of people know, but it's the fact that quite a few people also don't know answers to these questions. Now, if you ask them about CSIS or CBSA, the answer is 90% people don't know, right? So that goes back to Kent's point about oversight, right? So I'm very thankful, Ray, that you're here today. You're a former assistant director at CSIS. And it's invaluable to have a perspective from the ground explaining to us what it is to be in one of these situations and the kind of difficult predicaments that you're involved in and the issues that you have to confront right there in the thick of the action. And I understand that there are good reasons for why today there might not be somebody sitting at CSIS or any other of those agencies, right? Reasons of national security, that what they're working on is very sensitive, or if there are lawyers or questions of privilege, and these reasons are good reasons. But what do you think is the importance of outreach in all of this? The role of an organization like CSIS, or perhaps even CBSA, saying, you know, we realize that we're, at least for CSIS, a citizens organization, that's how you put it. And here's our role. You should know that we exist because in the end, we're accountable to you, the people of Canada. And so that goes to my question. How much do you feel there is an ethos within an organization like CSIS and CBSA or RCMP, to the extent that you can comment on them, of realizing that we are an organization constituted by law that operates within norms, and that we're part of a country that has certain norms and that wants to project certain values, and we ought to, for lack of official accountability mechanisms beyond a minister, ought to hold ourselves, at least, try to do the right thing. How much of this is actually really present in your experience? Because to be honest, I've been in forums in the US or in the UK where the CIA or MI5, perhaps MI6, they just don't say, were present, right? And you know, I would have liked to see people from CSIS or other agencies here today, and they aren't, so.
In my view, outreach and accountability and public confidence are equally important to an organization like CSIS as it is for law enforcement. It's the old ethos. If Chief Blair was here from Toronto, he'd tell you that the most important message that I have to convey and make sure my officers understand is that we're here to serve and protect, and we cannot operate effectively without the confidence of the public. CSIS is very much the same way. It's a human organization. It's about human intelligence. It's about recruiting individuals all over the country, at least gaining their trust to gain insights and to get some information that would help shape, hopefully, some government decision-making. So a couple of residual points of that. One is that I often took offense, and I don't easily take offense, but I often took offense when I hear from people that were tired of CSIS knocking on our doors. Well, I'm sorry, that's what we do. We could do it surreptitiously. We could secretly squirrel out and ferret out as much information, doing a whole bunch of technical things, but we're going to be very upfront about it. We're going to knock on your door, we're going to show your identification, and we're going to ask you if you can help us better understand an issue. Like, what's wrong with that? In my view, and that's part of the thing we do. So in order to do that effectively, you must maintain public trust, and there must be, I think, an effort to do outreach. Having said that, and I understand the culture within CSIS, I came initially from the RCMP because to join the security service in those days, I had to go through the front doors of the RCMP. Did drug work out in Vancouver for a number of years, and then I was part of that last transfer to CSIS on the day it was created. So I do get those organizations. It's difficult to move out of the coalface, move away from the coalface and do what you do investigatively and speak out publicly. And I think it's even worse for those in the intelligence business because the work was always done sort of surreptitiously or behind the scenes outside of the door knocking that happens. So there is a bit of a gap. I think it's being bridged in a lot of ways. There have been a number of outreach events that CSIS has led across the country in order to speak to numbers of community leaders, to explain to them why we do the work we do and how we do it. It's still not enough. These sort of issues, I think, are very important. I set out as an objective when I left, and I told the director who I reported to, I said to Dick Fadden, that I'm going to be out there because I think it's important to contribute to public discourse on national security issues. And I'm doing that, and I received the service's full blessing to do that. So I'm not their ambassador. If something I see somewhere, and I'm often on CBC, on the House or Power and Politics, if there's ever an event that I think the CSIS has done something wrong, I will say it. But at the end of the day, I'll do my most for now, at least explain the background, explain how things are done and why they're done in certain ways.
Francois, just to elaborate on that, CSIS has had a public outreach program. There's a lady called Louise Doyon who has run that, and effectively, Kent Roach and I were invited a couple of years ago to take two of our best students from our respective classes down to make a presentation within CSIS. And these are some of the, present were some of the lawyers and intelligence officers who were working on some of the most controversial cases. And those students made that presentation. They were invited. They had questions and answers just as we're having today. So that's one example of some of the things that go on. There are other instances of outreach seminars which CSIS has sponsored, and various academics or experts in the field have been invited for input. Not enough, but it's there and it's encouraging.
I just wonder why Francois is so sure CSIS isn't here.
Colin Fries. I should say Colin has been with us since the Arar days. He was the Globe and Mail reporter covering the Arar Commission in 2004, and we've seen a lot of each other since that time.
Yeah. Well, and that's what I was thinking about. I was just thinking, if there's a theme that runs through a lot of this torture discussion, is that Canada's biggest intelligence sharing ally has rewritten the rule book on how you deal with suspected terrorists. I mean, the lesson of O'Connor Yakabuchi is maybe there was some willful blindness with respect to the CIA rendition program, and so here's how we're going to correct things. In the SEC Cotter, you know, there was a bit of naivete about sending people down to Guantanamo Bay. This is how we're going to correct things. And so this has been the questions for the last 10 years, but I'm worrying about the questions for the future 10 years. And the one I wonder about, the big question is, to my mind, is, you know, the U.S. drone strike program. It's a secret program, but right now the U.S. asserts that a bunch of guys can get together in a room and sentence a person to death, and that's, the executive can do that with no judicial interference into that world. You know, so what happens when two Canadian citizens go off to Miramshah, Waziristan, and the CSIS person is tasked with picking up the phone and saying, God, what do we tell the CIA about these guys? I mean, that's the sort of brass tacks question I roll around in my mind again and again, and you wonder when there could be a judicial inquiry into that eventually, except should it happen, or if, you know, somebody's going to be dead and there's going to be no recourse. So if anybody wants to take a poke at that one, I'd love to hear the answer.
I think that's for you, David Cole.
Well, I think it's a good question. I think for me, the bottom line on the drone program is that the policy and practice should be transparent. I think there's a distinction between drones and torture. Torture is never permissible, even in wartime. Killing is part of war. Targeted killing is better than untargeted killing. We don't generally think that a judge should be deciding on who, you know, one army kills in fighting another army. And so, you know, where drones are used in Afghanistan to kill suspected Al-Qaeda or Taliban members, I don't think many people find that particularly problematic as a law of war kind of question. In the Pakistan border region, where the Taliban and Al-Qaeda have gone to reconnoiter and launch attacks back into Afghanistan, that's, you know, I think most people would concede that's effectively part of the battlefield. Much more complicated, I think, and much more questionable when you get far from the battlefield in places like Yemen and Somalia. And there, the actual criteria and standards the government is using is unclear. And you know, John Brennan is, who has been President Bush's sort of closest
CIA director,
closest national security advisor, has been named by Obama to be the head of the next CIA. He has said, if the president has the power to kill people, that the rules should be public. He has been fighting, as with a number of other people in the Obama administration, for more transparency on this. There are many people in the CIA and the Defense Department who don't want any transparency, and it's an ongoing battle. But I think sometimes people say drones just treat drones like they're torture. I think that's way too simplistic. It's a more complicated matter. It certainly warrants much more transparency, but it's not clear that it's always wrong to use a drone to kill somebody.
Thanks, David. Next question.
I kind of wanted to, I guess, direct it at...
Can you speak into the microphone?
Oh, sorry. I guess I'm going to kind of direct this more towards Cole. Considering since you just talked about Guantanamo, Obama administration not wanting to close that at the end of their term, many of the Bush-era policies, the Obama administration has actually continued and expanded on what's now called the disposition matrix, I believe, in which they can legally kill U.S. citizens without due process. They've redefined the entire term of enemy combatant to include anyone whose military age in a strike zone is automatically declared a combatant, and therefore you have to be posthumously proved innocent. So I was wondering, like, where exactly you have this hope that Guantanamo will be closed, and even if it is closed, that doesn't necessarily translate into indefinite detention somehow being ended, and those type of things.
Yeah, that's a great question. That's right. Closing Guantanamo and ending indefinite detention are two different things, and Obama has not promised to end indefinite detention. He's promised to close Guantanamo. He hasn't done either. Jay Johnson, who was the general counsel of the Defense Department, and is just now stepping down, made a speech in Oxford about a month ago in which he said, the war with Al-Qaeda is going to come to an end. And at that point, then and in the foreseeable future, at that point, we have to all these questions about detention and the like have to be reconsidered, because the premise for the detention is not we can lock up somebody who we think is a terrorist preventively and, full stop. It's we can lock up somebody who is fighting for the Taliban and Al-Qaeda against us as long as there's an armed conflict ongoing between the Taliban and Al-Qaeda and us, which is a more reasonable position than the former position. But at some point, that armed conflict will be over, and then there will be some difficult questions to be raised. In terms of my sense of should we be hopeful about Obama versus Bush, I think there are some major, major differences between the Obama administration and the Bush administration. I am a critic of both, but I think it's really a mistake to sort of paint them with the same brush. President Obama came into office and he closed the CIA black sites. He officially stopped enhanced interrogation techniques. He disclosed a whole raft of previously secret memos which had been written to justify torture, and he did so, he said, so that torture will not happen again in the United States. He promised to close Guantanamo. He insisted that we fight the war on terror within the confines of the laws of war, not throwing the law to one side as President Bush did. At one point in the Guantanamo habeas cases, the D.C. Circuit, which is the second highest court in the United States, and which hears all the Guantanamo habeas appeals, issued a decision in which they said, the president is not bound by the laws of war with respect to the detentions at Guantanamo. President Obama then filed a brief in response to that decision saying, you gave me too much power. I am bound by the laws of war. I must be bound by the laws of war. My detention authority is predicated on the laws of war. We can't ignore it. And the court reversed itself. When has an executive said to a court, you gave me too much power before? So I think it's a real mistake to paint them with the same brush. I'm very troubled by the drone policy. I'm very troubled by continuing secrecy. But I do think there's a basic difference between Bush and Obama. Bush's approach was, we will do whatever it takes to keep this nation secure. We will fight in response, but we'll do so within the frame of international law, of constitutional law, of statutory law, and that makes us stronger to do so. And I think he's tried to do that for the most part. So is he perfect? No. Is any president perfect? No. but I wouldn't paint them with the same brush.
Follow-up question?
Yeah. I just want to do a follow-up specifically on your take on redefining the term militant to be any military-age males in a strike zone.
Yeah, I don't think that's quite accurate. I think what you're referring to, if I understand you correctly, is the signature strike.
And the double taps.
Notion. The signature, so we have targeted killing where we identify a person who, as a high-level Al-Qaeda or Taliban person, and we, is he an operational leader? Yes. Can we find him? Yes. Let's wait until we can kill him without killing anybody else, and then kill him. That's targeted killing. There's also signature strikes where, say you're in Pakistan, and you're in the area where the Al-Qaeda is training, and you see a group of 8 guys engaged in what looks like training exercises, but you don't know their names. You don't have individualized information on them. Can you shoot to kill them? Well, again, if you use the war model, of course you can. No country in fighting a war has said before you shoot against somebody who's fighting against you, you have to identify who they are, get their name, and have some kind of process. No, if they look like they're part of the military, you can shoot them. Now, it's in most instances in traditional wars that's not problematic because the war people identify themselves as soldiers by how they dress, etc. In Afghanistan, it's much more difficult because Al-Qaeda and the Taliban don't wear uniforms, and so it's more difficult to determine who they are. But the idea there, I think, is look, if we're on the battlefield or in a battlefield area, and there are people who are acting in battlefield or military-like ways, we don't have to wait to get their name and social security number before we can take action against them. And I don't find that problematic in Afghanistan or Pakistan, where there's an ongoing military conflict. I do find that problematic in Yemen or Somalia, and for most of the administration, the Obama administration said we're not going to do that in Somalia or Yemen. More recently, they've said because of the level of conflict in, and I can't remember which country it is, that is a permissible tactic, and I think that's much more problematic. But again, I don't think it's redefining. I mean, they still would say, in terms of detention, we only have the right to detain people who are fighting against us. We also only have the right to kill people who are fighting against us. But on the battlefield, you can't always, give someone a trial before you shoot someone fighting for the other side.
But, I mean, if I can just jump in, David, I mean... I
didn't come here to defend you.
No.
You're doing all right.
No, but I mean, and I think you're aware that the war paradigm is a tougher sell outside of the United States. And so I guess the question is, if we accept your war paradigm and that the laws of war control, how do you get to Omar Khadr? And I know he pled guilty, but he pled guilty because he didn't think he was ever going to get out of Guantanamo. If this is really a state of conflict in Afghanistan and it's legal to kill people, it's got to be legal both ways, isn't it?
Yeah, I think that's a problem. Although it's not legal to kill people while not
in uniform.
Not in uniform. That's illegal for both sides. You have to be in uniform. Are the drones in uniform? I don't know.
He was 15. Remember.
Yeah.
Do you have any more?
Sorry.
We've got about 5 minutes to wrap before wrapping this up.
Okay, I guess I'll skip my follow-up.
No, please. No. You have the floor.
Yeah.
Okay, I was specifically referring to 2 things in particular. One was the New York Times article, which quoted Obama administration officials, in which they specifically said that the Obama administration counts all military-age males within a strike zone automatically as terrorists. And the second issue was our double tap strikes, in which we wait for rescuers to arrive or family members to go in after a strike, and then we hit them again with a second strike. which has actually, I believe, it's a Stanford NYU study, which says that these issues have actually increased the presence of Al-Qaeda in the Arabian Peninsula, particularly in Yemen. That was more where I was referring to.
The latter, I would say, is not acceptable, obviously. The former, I read that same New York Times article. It was it was not someone purporting to describe the formal categorization of who can be killed. It was a kind of a very kind of rough paraphrase in a kind of offhand way. And so here I would go back to my initial point, which is what we should have is we should know what the standards are, what the criteria are. I don't think killing people who are acting in a military fashion on the battlefield, if you define that appropriately, is wrong. It's clearly not illegal under the laws of war. But if the definition is the more rough sense that you are remembering from the New York Times article, that would be problematic, right? But we don't know because the policy remains secret. What we've had are very vague speeches. I mean, I wrote about this in the New York Review. I said, it's almost like, in trying to get a sense of what the drone strike policy is, it's almost like, how the Soviet Union's sinologists used to kind of interpret, who's in which picture to try to figure out what's going on with the Soviet Union's political structure. That's how we're trying to figure out what's going on with the drone strike policy. That's not acceptable in a democracy.
Thanks. One last question from Colin Freeze.
Anyway, sorry, you got a couple follow-ups, so I just wanted to follow up, and not to be grossly impolite to Ray, but does anything we've talked about in the last 10 minutes have any implications for any Canadian government agencies? I mean, it's just, you were talking about shared valued countries, right? And there's been a divergence, I think, between Canada and the U.S. on a number of issues, so how do you square that circle, basically?
It's difficult. We've had some difficult discussions. I, in the position of the DG of Counterterrorism, had some difficult discussions in Washington because there were certain things that they want to have access to that they weren't going to get because there was insufficient information that I felt that was, what we felt collectively, was in the U.S. interest or exclusively harmful to potentially harmful to U.S. interests, whether it's property or life. So it's an ongoing, difficult discussion. The drone element really rises that bar considerably, and exchanging information on a number of things that could lead to that ultimate executive action is a very weighty consideration, and one that we would spend a lot of time thinking about in the sense of how do you exchange, how do you deliver information that may end up leading to that type of extrajudicial killing, conflict zone or not, rules of war, understandably in a Canadian context or not. Not an easy answer. Again, case by case, each set of circumstances were different, but information must flow. Just got to make sure you do it the right way, involving the right types of details, and for the right reasons that will withstand scrutiny after the fact.
Does the fact it's an officially unacknowledged program, I mean, this came up in a RAR rendition. I mean, I think there was no CIA bullet points on this is our rendition program. It was an unacknowledged program at the time, so how do you, and yet it's in the New York Times every other day, so how do you actually, does that complicate the discussion at all, or is it just?
Yeah, I think the rendition thing took a lot of those early senior managers by surprise, in the sense that I don't think anybody understood what the American agencies, some American agencies had in mind when some information had been shared. So I think immediately there were some very quick lessons learned, and people suddenly started ensuring that the tap had a lot of filters on it, and that when information started flowing out, irrespective of the country, whether it is the Sweden, United States, or to a country that has a more challenging human rights record, that it was done properly. So same sort of thing. I know it sounds like I'm giving you the same answer, but it's just, it really was about trying to get it right depending on the circumstance of information we had in hand and who was going out to, and if it was, we always thought about which sort of outcome would come out of that particular sharing of information, which is something we wouldn't have done 10 years ago.
Colin, you'll recall that there was disclosure after Arar, the commission by officials within the CIA, that the rendition program had been in existence since the 90s and was started under the Clinton administration. And it was basically to get the terrorists off the streets, and it was an approved policy by the Clinton administration, but it had never been fully disclosed until the events of Arar took place 10, 12 years later.
Yeah, I think they evolved into out-and-out snatch jobs, basically, you know, like the Abu Omar situation in Italy. I guess, anyway, the 2001 era rendition program might have been a big step up from what was happening in the 90s, but that's anyway.
Ron, can I add something on that, what Colin was saying?
Yes, go ahead. Okay.
Yeah, I know we have to end, but I think Colin's final point there is correct, is that it's definitely the case rendition, and they actually use the word started under the Clinton administration. But unless there's something we haven't found out, the approach they took was they were grabbing people and taking them to countries that had arrest warrants. It wasn't it's all clear in any information I have that they were doing black holing or anything resembling Guantanamo. So there's a definite distinction. So.
It was rendition to justice instead of rendition to torture.
I want to thank, on your behalf, I want to thank Kent and Ray and David for their very significant contributions to the discussion. Francois, I'm going to turn it over to you.
To respond to Colin and Craig, to quote the ever-lovable Newt Gingrich, it's all about Canada anyways, so we shouldn't worry too much about the United States. Okay, so we've run a bit over time, so just to make sure that we have a little leisurely break to do what we all need to do, we'll reconvene at 4:30 instead of reconvening at 4:20. So enjoy the tea coffee.